proceedings of civil nature. In all proceedings of civil nature means when the dispute is purely civil, or a dispute is in personam, or a dispute is between two parties, one party initiate and another party defend the case. Definitely, a husband can give evidence against a wife can give evidence against the husband. But the position of criminal case is a little bit confused and different. This can be considered from different angle. So the husband-wife communication, we know, is considered to be a privileged communication. And why this communication is considered as a privileged communication? Under Indian Evidence Act 1872, you know, is basically a Victorian law. Marriage is considered to be a sacred, fundamental institution for the very existence of the society. According to the traditional Victorian law, husband and wife is one and only person, not only for the purpose of physical union, but also for the purpose of all communication between husband and wife, and even for taxation. In the eye of law, husband and wife can be considered to a considerable extent a single legal entity. So here, a communication made between a husband and wife in a criminal proceedings means a husband cannot be compelled to give evidence against his wife. A wife cannot be compelled to give evidence against her husband. Because when the dispute is between the state and the husband, when the dispute is between the state and the husband, or the dispute is between the state and his own wife, the instrumentalities of the state, simply means the police officers cannot compel his life partner to give evidence against his own wife, or to give evidence against his own husband, his own husband. The reason is that family as an integral basic social institution is recognized. So when you are giving evidence against your own wife with respect to serious criminal offense, of course you can give, provided you are giving it voluntarily. But the state cannot compelled in the sense, the state cannot, without your permission, include you as a witness. And the prosecution cannot compel you to give evidence. This is the purpose of section 120. 120 is a little bit controversial in the sense the privileged communication is only between husband and wife. We know that there are so many other privileged relationship inside family. For example, the relationship between a mother and son, a relationship between a father and son, daughter or father and son, the relationship between brothers. All those relationships are definitely very sacred, and it ought to have been privileged. And marriage, after all, is an artificial relationship. Artificial relationship in the sense that both the parties are entering into marriage. It's a little bit different from blood relationship. But under the traditional Victorian law, the communication between the husband and wife alone is treated as privileged. And the person who is excluded from giving evidence is different from conduct. And what is the difference between evidence and conduct? Can anybody say? Evidence and conduct. For example, suppose the accused came late at night at 10 o'clock, knocked at the door, wife opened the door. Without making any statement, he rushed into the house, hand over or secretly concealed some gold ornaments inside a shelf without uttering a single word. The accused ran away from the house. Here, a wife cannot be compelled to give evidence only with respect to what is spoke to him. Here, nothing was spoke in between. There was no communication between husband and wife, here the word used is communication. Communication is little bit different from contact. Communicate means I am communicating with you. So whatever we are communicating is privileged, but my conduct is not privileged. Here, if a person comes with a bloodstained knife inside his bedroom, and he told to his wife that I killed B. Thereafter, he washed the bloodstained knife, concealed it inside his bed, and ran away from the house. The fact that the accused came to the house late at night, showed the bloodstained knife, washed the same, and concealed the originally bloodstained knife, washed bloodstained knife inside his bed. To that extent, the evidence of the wife is admissible, because all these things is nothing but the conduct of the wife. Sorry, conduct of the husband. The word I killed B is the only communication between husband and wife. This communication is a privileged communication. And the court cannot compel the wife to give the statement that my husband told that I killed B. That statement cannot be compelled. If the wife voluntarily give, you can't say anything. But if prosecution compel the wife to say that husband disclose you that he killed B, you must is right. Such a question is inadmissible in evidence, because it is a privileged communication. The conduct of the husband, that he came at 10 o'clock with a bloodstained knife, showed the bloodstained knife, washed the bloodstained knife, concealed or hid the bloodstained knife inside the bed, beneath the bed, ran away from the place. Everything is admissible in evidence. And what is not admissible is only the communication. Hope you understand. I think so. Or any confusion or any doubts regarding that? Yes, thank you, sir. And another interesting point is what? Thank you very much. And what is the purpose of this communication? And why this communication is usually considered as a privileged communication? As I have already stated, the communication between a husband and wife is different from the communication between other parties. Like the communication between a mother and son is different. Sometimes the communication between a husband and wife is sexually colored. You cannot compel a husband or wife to disclose what they are exchanging in their private, in their privacy. If we are compelled to give whatever statement a husband disclosed to wife and wife disclosed to husband in a public forum, that may not be healthy. This is another reason. But at the very same time, we can see at the first part that in all civil proceedings, the parties to the suit and the evidence of the husband can give evidence against the wife, and the wife can give evidence against the husband. So originally, when this section was enacted, there was no family court, So the dispute between the husband and wife at that time is a civil dispute. So when husband filed a suit against the wife, or wife filed a suit against husband for divorce, basically this is a litigation between the parties, not against the third party. So when a litigation is against a wife or husband on the ground that the party want divorce on the ground of adultery or cruelty, definitely the other party must be permitted to give evidence against her own husband or wife. The basic distinction is here in the first part, in the first layer, the parties to the suit are none other than husband and wife. So they are throwing mud to each other. They are disputing their claims contradictory to one another. So in order to resolve the dispute, they must be compelled to break what we call the matrimonial oath, the matrimonial fidelity before the court. For the time being, at least for the time being, they are not husband and wife. Here, another dimension is that the scope and extent of this section also extends to extends to proceedings even after divorce. So what is crucial is whether during the relevant periods he was or she was husband or wife, not whether he is husband or she is husband. So when the incident took place, so the crucial test is when the incident took place, what was the status? At present, you may be stranger, but still we cannot tumble. And this is an interesting section. And this section is what we call the privileged matrimonial communication. Okay. Yes, sir. So what's the time now? I think 7:30 already.
You can take 5 more minutes, sir.
Yes. 5 more minutes means, sir, I have to go to the other section. Other section is also a little bit.
No problem. Then we can wind up. Yeah.
So the next point is judges and magistrates. Shall I proceed or not?
If it will.
Okay. I will just give an introduction to that and will complete.
Yes.
We know that usually a judge and magistrate is the person who decides the dispute. So when a judge or magistrate is compelled to give answer with respect to any question during the exercise of his own judicial proceedings, that will cause so many problems. So we know that judge or magistrate is sitting as an impartial arbitrator to decide the dispute between the parties. So when that person himself is compelled to give evidence regarding his conduct or character, definitely the trial will not be smooth. The trial will be vitiated by so many dramas and the case may not be running smooth. I will give a simple example. For example, during the examination of a witness, the judge is not ready to write down a question, which in the opinion of the prosecution or which in the opinion of the defense is very vital. Judge says, no, this is an irrelevant question. And the counsel is compelling the judge, you must write. Judge says that in my opinion, as a judicial officer, your question is irrelevant. It is baseless. I'm not going to write it. The court cannot compel the judge that you must write. If you are aggrieved, you can file appeal before the superior court, and only from an order of a superior court subject to which the judge is functioning. The party to the proceedings cannot compel the judge regarding the conduct of the judge inside the court. Suppose you are saying that the judge appears that he is going to convict the accused. Every day he's making comments one after another in such a way that he's going to convict the accused. Or the judge is sitting here not as an impartial person. At every time, at every moment, the judge is with the prosecution, the judge is with the accused, the judge is with the plaintiff, the judge is with the defendant. You cannot take such a plea during the course of trial. If you are aggrieved, the only remedy left with you is to approach the superior court and obtain an order from the superior court. Only after obtain an order from the superior court, you can restrain the judge from acting in a way prejudicial to the interest of your party. I think this section requires a little bit more time, and we can discuss it in the next session, because 30 minutes itself is more than sufficient in an online class, and you may be a little bit bored by different sections. I think we can wind up today. Is there any doubt regarding the first 3 sections, 118, 119, and 120?
നിങ്ങൾക്ക് എന്തെങ്കിലും സംശയം ഉണ്ടെങ്കിൽ ചോദിക്കാം കേട്ടോ. സാറിനോട് ചോദിച്ചു കഴിഞ്ഞാൽ സാർ അത് ക്ലാരിഫൈ ചെയ്യും.
Who may be a witness under section 180? Every person is a witness. The only test is he is unable to give rational answer to the question because of either because of some disease of mind or disease of body. Disease of body may be caused by two reasons: tender age or extreme old age. A person who is capable of giving a rational answer to the question, who can understand the question and who can give rational answer to the question, is a witness. Whether he is a minor or a person suffering from some little degree of insanity is not a ground to totally discredit a witness from giving evidence. Physical incapacity is also not a hindrance. He may not be, his vision may be blurred. He may heard something, but he may be a blind person who heard something. So what is a fact? You know, anything, state of thing, relation of thing, capable of being perceived by your sense is a fact. So it is not necessary that you must be, you must saw everything. You may smell something, you may hear something, you may experience something through your skin. Then also you can be a witness. The second part says that even a dumb witness, a person who is unable to give evidence, is a witness. Then we have discussed matrimonial communication, basically and fundamentally a Victorian concept. Now even the concept of marriage itself is fastly undergoing changes. It is doubtful whether a person living together relationship can be considered as a privileged communication or not. No, there is no particular age limit prescribed. But still we know that, take the case of an 1 year baby or 2 month or 3 month baby. We can understand that at the first sight itself, he is not able to give evidence. But take the case of a child in the kindergarten. He is in 3 or 4, and that child at the age of 4 or in between 3 and 4 is the only witness of the incident. Void dare test can be applied.
Thank you.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional